Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket for December 13th, 2023. All matters being heard today are being heard in accordance with all protocol regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, will you call our next case, please?
Yes, Judge. Towards the bottom of page 2, Judge. In cause number 2022 DCV 0441, Joel Sainz Flores versus Mario Hector Hernandez Jr. et al. Announcement of counsel, please.
Mr. McElroy, you're muted.
Your Honor, Jeff McElroy with Lovett Law Firm on behalf of the plaintiff, Joel Sainz Flores.
Jonathan Kavanaugh on behalf of defendant Hernandez, Your Honor.
Cliff Jessup on behalf of defendant Progressive, Judge.
Okay, looks like we have an agreed motion for continuance here. We're at final status now. I'm trying to pull this up because I feel like I reviewed it. I don't remember, so let me look at it. Yes,
Your Honor, I can give you a little bit of synopsis about how we got here, or rather how we didn't get here.
Oh, okay.
You might recall I filed this suit early, long before the statute of limitations ran, in order to start getting discovery on it, because there was a counterclaim that was being proffered by Mr. Kavanaugh's former client. That counterclaim originally was held by Wainwright Firm. They had presented the claim to the insurance carrier, and it looked as if we were going to have a full-blown liability contest with the insurance carrier, basically, who has hired Mr. Kavanaugh, also supporting the defendant's counterclaim for liability. Ultimately, Mr. Wainwright's firm dropped the case or referred it to Fred Mandel. Fred was in for a while, and we couldn't get any kind of movement in terms of discovery, getting everybody ready to exchange written discovery, and more importantly, we couldn't get depositions scheduled. After some mysterious developments, which none of us really know, the defendant dropped his counterclaim. And when he dropped the counterclaim, we were in the process of doing a new joint scheduling order, which basically everybody signed off on, but it ended up only affecting me, Mr. Kavanaugh, and Mr. Jessup. Now, in the meantime, we've taken my client's deposition, but we've had to cancel Mr. Kavanaugh's client's deposition twice because he had things come up that made it unavailable. So we're not yet to the point where we know if we need liability experts or not. I'm not certain what he's going to say as to how the accident occurred. So I think now that we've got the parties cleared out, I've also given Mr. Jessup an abatement so that he does not have to participate any further. What we need to do now, and Mr. Kavanaugh and I are working on dates right now, is to get his client deposed and then move forward to determine if we need liability experts. The medical's pretty clear cut. I think it's just going to be a matter of taking the healthcare provider's depositions and finding out what the costs were and what the future costs are. But we do also need to, I think, depose the 911 callers. Those will be short depositions. And we need to depose the sheriff's department who investigated. The problem is we need to get the defendant's deposition first. So that is the case in a nutshell so far.
Well, thank you, Mr. McElroy. And so as I'm going down the entries here in Odyssey, the first or the most recent was the agreed motion for continuance, but then I see the order of abatement. So that, I guess, pertains to you, Mr. Jessup?
Yes, Judge, that would be the first party severed and abated.
Okay. Are you still urging your continuance?
Yes,
I think so, Your Honor. We're just trying to make sure we have enough time to just get it wrapped up one way or the other.
Okay, so I have you down for a final civil pretrial. I mean, I don't have a problem with that. In fact, I think in terms of the motion for continuance, the only reason I asked you I'll be here is to have an idea of if we should set it for a status or can we utilize the January 24 setting as a status and before I put it on a trial track, or do you all want to come in and do a whole new scheduling order, and do you have a trial date in mind? So you tell me.
Your Honor, I think we probably do need a whole new scheduling order because, again, depending on what Mr. Hernandez testifies to, we may or may not need to. We've retained an expert.
Okay.
Everybody knows who he is, but we're not going forward with him as a testifying expert until I get the deposition to figure out what Mr. Hernandez is going to say happened that evening. So I think we can do a joint scheduling order and get it to you before Christmas. and anticipate a new trial date maybe in July or August of next year.
Okay, so let me give you that date. Myrna, do we have an open setting in August, something that we do not have a special setting? I'll take this as our scheduling status conference so we can have a date and then normally I ask you. Yes, ma'am.
August 16th and August the 23rd. Do not have any.
Are either of those dates, do either of those work for both of you?
I have no objection to either one, Your Honor. I'm clear as far as I know.
I can't imagine I have anything that far out, but let me look just to be safe. August. I believe either of those dates are fine, Your Honor.
Let's use the 16th then. Your docket call will be August 14th. That means we'll have a final civil pretrial, let's see, right around July 17th. So that means a mediation deadline is July 16th. All those other dates, I'll just rely on you all to fill out that scheduling order. Had you already agreed to a mediator?
I can't remember if we have or have not, Your Honor. I think we're okay.
An agreed mediator on the scheduling order. I'm going to say if you all can return it to us by next week, because if not, we're probably looking at 2024. Okay, you all can do that.
We can do that.
Perfect. So we'll have that entry of scheduling order next week.
Okay. Thank you, Your Honor.
Very much. Thank you, Mr. Jessup.
Thank you.
Still there.
May we be excused?
There you are. Yes, you are.
I appreciate the help. Thank you all very much.
Okay, who's next?
On page 1, Judge, the 2 on the bottom. In cause number 2022 DCV 0054, Eduardo Contreras et al. Versus Carlos Nunez et al. Announcement of counsel, please.
Yes, Your Honor. Carlos Quinones on behalf of the plaintiff.
Marwan Bhatti on behalf of defendant and counter plaintiff Carlos Nunez.
Roy Brown on behalf of defendant Joel Luna, DBA Optimus.
Bear with me. We're scheduled for both the motion to compel and summary judgment. Give me 1 second. And a final civil trial. Is that right? Okay.
That's right, Judge. And there's actually 2 motions for summary judgment by both defendants. Yeah.
I see that. Bear with me. Accessible. Okay, and it looks like today there's a motion for leave. Bear with me. Okay, Mr. Quinones. I had not seen this one. Counsel, had you seen the motion for leave filed by Mr. Quinones?
I barely had a chance, Judge, to kind of take a glimpse at it, but didn't get a chance to write a response or anything yet.
Okay. All right. So, Mr. Quinones I've got to think that this is related in some way to maybe some of the issues on the motions for summary judgment. Am I correct or no?
Correct, Judge.
Yeah, tell me a little bit about your motion for leave.
Well, I mean, simply put, the motion for leave is to amend the our filed complaint, our filed petition, due to some of the revelations that have occurred since we filed this complaint. We've had several depositions, and so based on that, that's why we're asking to amend the pleadings. I know that, I guess at this point, Judge, before we continue on the motion for summary judgment, we do have an outstanding deposition left there's been a witness that's avoided 2 depositions in this case. One was by court order. The first one was by subpoena, and the second was by court order. So so I filed a second motion to order appearance at deposition. I'm requesting a capias in that case. We haven't finalized discovery based on this lady's avoidance to appear at a deposition. She's a critical witness in this case in that she took money from one of the partners, the defendant, for no apparent reason. And it was the company's money. And months later, that money was refunded. And we still don't have an explanation as to what happened with that money.
Okay, and I do see here on December 6th, there is a second motion to order appearance at deposition. That's for Diana Favela. Is that right?
Yes.
Okay.
And there was two depositions that she not appeared was December 12th and February 21st of this year.
And let me see, there's a response. The response is to the motion for summary judgment. Okay, so you're asking for relief to get Ms. Favela here, but how, can you tell me how that relates to the motions for summary judgment?
Yes, Judge, one of their claims is there's no evidence to support that claim about the $7,000 payments.
Okay.
And so that's directly.
Okay. I understand. Let's go ahead and start on the motions for summary judgment. Who is going to go first? Mr. Body, or was it Mr. Brown?
I don't mind if Mr. Brown wants to go first because he's got one issue, then I've got 2 additional issues in mind that.
Okay, Mr. Brown, let me hear about your summary judgment.
Thank you, Judge. By the way, I just emailed to Mr. Marufo a copy of our file stamped first amended and supplemental traditional and no evidence motions. And then today I filed a reply to the response. And so I don't have a file stamped copy, but I sent the court a copy of my reply, which contains an objection as well.
An objection to what, Mr. Brown?
To evidence. But I think I can just argue it all together.
Okay. And that's generally for counsel, what I'm going to be asking, because it seems like we're getting some late filings here, is that you all proceed, and I'm probably going to have to follow up with some review on these later filings. Go ahead, Mr. Brown.
Sure. My client is a bit of a bit player in this drama. He's a third-party vendor, and all he's alleged to have done is to have converted some building material that was on top of a trailer that he rented to the company, who I'll just refer to from here on out as BTI. And so I filed a motion for summary judgment basically on 3 grounds. One is on the pleadings themselves, and the second is on a traditional motion for summary judgment, third on a no evidence, and they all go to the ground of whether they can prove that my client wrongfully exercised control and dominion over this building material that was on top of this trailer. The summary judgment evidence is fairly clear that my client was approached by an employee of the company who was the brother of Mr. Nunez about the company needing a flatbed trailer to store this building material. My client, Joel Luna, DB Optimus, he provided the trailer. Mr. Contreras was there when he provided it. He told him where to move the trailer. My client's basically a truck driver. And the trailer, to my client's understanding, was going to remain there for about 3 months. And my client, as if you look at the motion, it'll show that he tried to contact the company in the interim just to check status about a month before he was to pick up the trailer, which was on November 2nd, 2021. On that day, he arrives with another gentleman who was the owner of the trailer, a guy named Justin Merida. And they were there to pick up the trailer. They actually spoke to the secretary of the company, Dicel Juarez, and she went through the process of according to my client, calling Mr. Nunez and ultimately Mr. Contreras about what to do with this trailer. And eventually she opens the gate and allows the trailer to leave. It does have the material on it, and Mr. Merida, the owner of the trailer, is the one who hauls it off. There's no question about that. There's no question about the fact that my client arrived, he talked to the person he needed to talk to, who in fact got hold of the plaintiff, which is why this motion is relevant, Mr. Contreras, to talk to him about the fact that my client was there to pick up the trailer that he had rented to the company. And Mr. Contreras, in his pleadings, that's the first basis of summary judgment, he says at one point that my client wrongfully took the trailer. Then he files, and then in his next paragraph of his pleading, he says, but in truth, what happened was that Carlos Nunez conspired, or not conspired, but worked to hide the building from him. So my argument is that in the first place, his own pleading says that my client did not wrongfully take the trailer or exercise dominion or control over it, that it was in fact, in truth, according to his own petition, Carlos Nunez who secreted this building from him. Furthermore, in Mr. Contreras' deposition, I asked him whether he had any evidence to show that Carlos Nunez in fact took the trailer, or excuse me, took the building as he has alleged. And he said no. And in fact, that's what his own affidavit attached to the response says, even now that he filed before this hearing, filed it 7 days before. Additionally, I asked him specifically, and I set out his testimony verbatim on this question. I asked a couple questions. I said, you admit that Dicel Juarez was authorized by the company on that day to release the trailer and this material? And he says yes. And I said, and you have no evidence that my client wrongfully exercised dominion and control. I said, wrongfully took it, do you? And he said no. So the long and short of it is that there is no evidence in their response that controverts that clear testimony or controverts their own pleading, whereby he equivocates when he first says my client took it and then says no, it was Carlos Nunez. So summary judgment is appropriate whether it's on the pleadings or whether it's traditional summary judgment where we say that there is no evidence or that the evidence before the court conclusively establishes the affirmative defense that we didn't exercise control over it, or there's no evidence that they have produced that proves that element or raises a fact issue on that element of wrongful control. I objected to Dicel Juarez's affidavit because it fails to state that it's based on personal knowledge. It states something to the effect that it's based on her best knowledge and what she best remembers. There's specific case law that says that's insufficient. I also objected to it generally because it doesn't contain facts showing that she did have personal knowledge as to many of the statements that she made. And that basically sums it up. The last thing I did, Judge, I filed a motion for leave that's contained within my reply to attach my invoice for my fees, because I also argued as a part of my summary judgment relief that these pleadings were baseless if you just look at the pleadings, and therefore we should get our attorney's fees as a sanction because Mr. Contreras admits he didn't have any evidence, yet he brought my client into this who's now had to spend money to defend this matter. So I asked for leave to attach my invoice, which I inadvertently failed to attach to my affidavit for fees, which I attached the affidavit to the motion for summary judgment for whatever reason I've I failed to attach the invoice that I reference in there that itemizes those fees. There is case law that says if that's a defect in form and if it's not objected to, it's waived. And so I would argue that I'm able to supplement, and I'd ask the court for leave. I attach the invoice and I'd ask that that be a part of the court's record.
That will be granted. All right. Anything else, Mr. Brown?
No, Your Honor.
Mr. Quinones, how do you want to respond to these? Do you want to respond to Mr. Brown first, or?
Yeah, that'll be fine. We could do it individually, Judge.
Okay, go ahead.
Yes, Your Honor, if you take a look at our response, essentially the affidavit by Danitza Juarez states exactly that the people that approached her was a clear representation that this was D. Optimus, and the DBA, we filed against D. Optimus, DBA Joel Luna. If you hear what counsel's saying, is that they were contracted to lease a trailer, and they picked up that trailer on that day. What we're talking about is the building material that was on this trailer. No one has said, and no one has stated where this building is at. It's a $30,000 building according to my petition. We're not talking about the trailer. We're talking about where the building is. And for the optimist to say, well, we had a right to take that trailer, doesn't answer the question of where the material is on top of the trailer. Not only that, but when Optimus was contracted to take the building to 119 Atlantic, that never happened. And that was signed by both D. Optimus as a driver and Carlos Nunez as owner. And so there's clear evidence that this wasn't done. And the affidavit that Sal Juarez states on there clearly that it was Carlos Nunez who allowed the Optimist to take this trailer. And so there is some sort of conspiracy or hiding of the material. Forget the trailer. Where is the material? And to this point, of course, both the defendants have essentially denied any existence of this material or building material. And so I think a reasonable jury can conclude or make a determination that these individuals conspired or because of the relationship that has been established, that the brother of Mr. Nunez, because of the relationship that with the brother of Mr. Nunez had with Joel Luna, that there's enough evidence there to have a jury conclude that the conspiracy between Mr. Luna and Mr. Nunez, they conspired to take this building material away from the property. And that's also corroborated by the affidavit of Denzel Juarez, who mentions that at the time of the pickup of the building, there was mentioned that there was previously offered him to buy the building material. There's mention of the building material purchased. And so even by the affidavit, if you read the affidavit, there's mention that first that Carlos Nunez allowed allowed the Optimist to pick up the building and the material. And then there's mention that there was previously offered to buy the building material. And then there's mention that at some point that Ms. Juarez, after contacting my client, told them not to leave, to leave the building material there, and that the sheriffs were called immediately thereafter. So clearly there's evidence to suggest that these people converted the building, that there's been a clear conversion by de-optimists. It's irrelevant why they took the material, why it's irrelevant why they took the trailer. What's important is the building material on that trailer. Let's say de-optimists had a proper removal of that trailer. There's material on top, and they knew that. And Tetzel Juarez made it clear that they knew that. And that's what we're arguing about, Judge. That's why we're here.
Okay. Is that it, Mr. Quinones, on that one?
On that one, Judge, that's it.
Okay, Mr. Brown, do you have anything else?
Just briefly, Mr. Quinones is referring to some evidence. He claims that his client, Mr. Contreras, told Ms. Juarez to tell whoever picked up the trailer to stay there, or my client to stay there. There's a few problems with that. There's no evidence of that in the summary judgment record, whether you look at her affidavit or the testimony. It's clear that Carlos Nunez authorized release of the trailer. There's also some testimony by my client that I put in the motion whereby he did say he had some communications with Mr. Contreras about whether he knew of anybody that wanted to buy the building, but he ultimately said he didn't. And at the time, my client testified, and this is without objection on these motions, that the person who took the trailer was the owner, Justin Merida. And there's no question about that. It's undisputed. And the fact of the matter is, Carlos Nunez, an authorized agent of the company, as was Tetzel Juarez, opened the gate, released the trailer. Mr. Merida took it. My client didn't. And the issue is wrongful dominion and control of the trailer, period. And I think that about sums it up, because Tetzel Juarez's affidavit, even if you say that it's not objectionable because it's lacking in form and substance, does not say that my client was told to stay there or do anything in relation to that trailer. And also Mr. Quinones says, well, de-optimist was identified as several individuals. That's part of the problem, and that's why I objected to the affidavit, because there's no predicate as to who she's in fact talking about. If it's Joel Luna, who is a sole member of de-optimist, or other people.
All right, Mr. Body, go ahead.
Judge, I'll kind of piggyback on the arguments on this. So my summary judgment, it encompasses two other factual issues, but this issue of the trailer and the missing building material is one of the allegations against my client as well. So, I'll incorporate all the arguments also within the motion that Mr. Brown filed a similar motion for summary judgment on the same issues. Some of the things, and you addressed this right before we got into these motions, Judge, but one thing I'll kind of remind the court, at least on the history on this case, is that it's been going on for 2 years since the beginning of 2022. So we're set for trial, now in January, which means that plaintiff had 2 years to develop his case. It's his case that he brought against the defendants. He's had 2 years to develop it. We had, I think, 7 to 8 depositions on what is really a partnership dispute between my client and Mr. Quinones. They were just two business partners in a company, 50-50, that just didn't get along. And, as this company is kind of starting to fall apart, they're not communicating, this little dispute arises over this building kit they bought, was to construct like a metal barn type building. And so they're not talking to each other. And so they leave it outside, out in the open. at their site. And so one guy says, well, they had to come pick up the truck on which the building kit was on. Nobody really takes ownership of it. The truck is, leaves presumably with the building kit on it. And so, really on the motion for summary judgment, first of all, I'll say this is that plaintiff did not respond to the no evidence portions on my motion, or I believe Mr. Brown's motion. They've got to come up with a scintilla of evidence as to the elements that are in dispute on the causes of action that they brought. Now, plaintiff brought, I think, 7 to 8 causes of action: breach of contract, fraud, negligent misrepresentations, conversion. He's got to go through and provide a scintilla of evidence. And the best evidence they could come up with was an affidavit after the fact from a secretary, one of the only people not deposed, which by itself is defective in form, as Mr. Brown pointed out. The affidavit by Daisal Juarez, it contains double hearsay, her recollection of conversations of what other people were saying. And after 2 years, Judge, that's the best evidence, the only evidence he's got to go forward to trial in January. And I would say it's inadequate. And our motion, both my motion and Mr. Brown's motion should be granted. I will say this, Judge, that is that if you're inclined to granting Mr. Brown's motion and the allegation against his client is on conversion, it's a similar issue with my client, at least as to the trailer. And I think it should be granted, for my client on that issue as well. The best evidence as well in this case, Judge, is we took the deposition. So Mr. Contreras, the plaintiff, has already been deposed in this case. And he's stuck with the statements now that he made in the deposition. And in his deposition, he goes through, and we actually went through his petition and his allegations. He did not have any evidence to back up anything that he was claiming. And he admits to it. He was very actually truthful at his deposition. One of the other things, Judge, on this trailer and building kit issue that went missing, Mr. Contreras then contacts El Paso Sheriff's Department, tries to make a report. It was investigated by Detective Munoz, and his deposition transcript is attached to my motion. Again, this goes on the conversion issue of the building kit. The detective goes through and says, I didn't have enough to present to the DA. The DA declined. I investigated. I found nothing. I found no conspiracy between my client and Mr. Brown's client. So, Sheriff's Department went through it, found nothing. They filed this lawsuit after 2 years, have no evidence. I mean, a couple affidavits, and one of the affidavits, Judge, that Mr. Contreras filed on his response to my MSJ was his own affidavit. And so now he goes through and tries to negate his own deposition testimony that we took, which actually is a mistake because he's now making statements contrary to his deposition. Now he's given inconsistent sworn statements, under the penalty of perjury. And so, you can't go through and then try to correct what you said in a deposition by filing then another affidavit to respond to an MSJ. That doesn't work. And a lot of the tactics, Judge, on the part of the plaintiff have been to delay. We were set, I think, for trial earlier this year, and we ended up having to move the trial setting. I think there was the conflict with the court's schedule, I think, at the time with other trials that the court may have had. But I bring that point up, Judge, is because the scheduling order then was also revised again. And so there was an opportunity for discovery. And so when I heard Mr. Quinonez's argument, said, well, we need more time for some discovery on these issues. We need to depose somebody else, that didn't show up for a deposition. That person was a third party, Judge. And by the way, there's no explanation by the plaintiff. He wanted a second deposition of this person back in February 2023. We're now in December. Zero explanation for 10 months sitting on it as the plaintiff, doing nothing about his case, trying to prove it up before trial. Now the deadlines for discovery have passed. The deadlines to amend the pleadings have passed. He's filing these late motions to amend his pleadings. I mean, it's all delay tactics, Your Honor. The net result, Judge, is that if he's allowed to amend his pleadings, reopen discovery, which would be a third time, after 2 years of not showing any proof other than these 2 affidavits that he provided, it causes my client enormous expense. This is not a case where insurance companies are paying the bill. My client, Mr. Nunes, is a real person. And so, we've stuck with the deadlines, Judge, and I think the plaintiff needs to be bound by those too. And actually, the pleadings deadline was not too far ago in time. I think it was in the last month or so. So there was an opportunity, but I think it's a last-ditch failed attempt to try to respond to the motion for summary judgment. And I read the responses to my motion, to the motion of Mr. Brown. To me, they were inadequate. I mean, he doesn't address things. And if it's okay, Judge, I'll kind of get into my motion now a little bit more. I was just trying to address Mr. Brown's if the court wants to do it. And so on our motion, Judge, again, so I've covered the conversion issue. The other issues I want to mention now are that I sent requests for admissions. He blew through that deadline, the plaintiff. In his response, does not address it at all. Those are deemed admitted. He had to show good cause on why he wasn't able to respond. And those requests for admissions now go to the heart of the matter, on top of the other evidence that we actually have to show that they don't have a case and that they've not met their burden. They've, like I mentioned, Your Honor, they allege 7 or 8 causes of action. He's got the burden to show at least that he has a scintilla of evidence, and he does not address my no evidence part of my motion at all. So that and the request for admission are the 2 biggest things that he just does not address in his response. And I think on those bases alone, you could award my client summary judgment. Now on the other factors, and I'll give an example, Judge, because it's a very long motion, long response. I don't want to lose you here, but he sues my client for breach of contract. My response is, okay, what contract? No response. What contract did my client breach? I mean, I don't even know to this day what contract he's talking about. And we went through that with Mr. Contreras when we took his deposition, and I kind of break it out in my motion on all the different allegations we go through. The other 2 allegations that he kind of brings up factually that are the principal allegations. Number 1 was that conversion of that building kit. Number 2, he says that they did some job at W Silver Recycling for about $7,000, and that those profits weren't shared. In his response, he admits that they had some corporate meetings about this dispute on, hey, you didn't share the profits from this job. And actually, attorney John Granberg conducted that meeting. He was the company's attorney at the time. So these 3 sat in a room together and they worked it out before this lawsuit. And the plaintiff accepted $3,000, as to resolve that dispute. Now, why do I bring that up? He's got to go through now and prove that he's had damages. And that's one of the, the issues in my summary judgment, Judge, is that on every single one of those causes of action, negligence, fraud, he needs to show that he's been damaged. And in fact, he's not been damaged at all, because those were issues that were resolved in the windup of the company. One of the other big issues, Judge, and this is a big one, is the court currently, there's about $101,000 in the court's registry. When I started this lawsuit, I filed a counterclaim on a derivative lawsuit, and we had an agreed temporary injunction. There was money for the company that was floating around. We basically impounded that money and put it in the court's registry. So it's sitting there, and the court is going to have to make a determination on how to split up that money. There's an acknowledgement by Mr. Contreras in his depo testimony. And also there's no response by him in his MSJ to my in his MSJ response, because I asked the court to rule on our declaratory action, finding that the owners both own the company 50-50, the expenses of the company need to be paid, and then it needs to be divided 50-50. There was no response at all by Mr. Contreras in his motion to that point. So I would argue that that is now waived. The money, you know, it's been sitting there. It's not really gaining any interest. And there's actually issues like property taxes, things like that, Judge, that need to be paid on property that is owned by the company. We actually did a mediation with Judge Ancliffe about a month ago or so. It was mid-October. And we reached a partial agreement, and I haven't filed this motion with the court yet, but we reached an agreement to distribute some of those funds to pay property taxes, things that were due. And I've forwarded to Mr. Quinones, I think 4 or 5 times. We agreed to do a joint motion, had no response. And I was still trying to give them an opportunity before today. I knew that we had put 3 or 4 motions on the court's docket today, that there wasn't enough time for the court to go through all this stuff at once. But, you know, the basic issue, Judge, and, you know, I'll kind of rely on our pleadings, is that they've waived a lot of the issues that they may have by their response. I think their response to both of our motions are inadequate. They rely on affidavits that contain hearsay, that are not credible. And Mr. Contreras' testimony is front and center in my motion, and I believe in also Mr. Brown's motion. And he's honest. He goes there, I don't have any evidence of anything. He filed this lawsuit, Judge, asking for $100,000 in actual damages and $1 million in special damages. And the questions we went through in the deposition, I said, can you substantiate it? How do you come up with $100,000? Well, I don't really know. But I have evidence, I'll produce it, but I don't have anything. You know, he actually tries to guess at the damages, but does not know them. And 2 years into this lawsuit, he's stuck with it. Now, one of the other things I have got, Judge, scheduled today is our motion to compel for sanctions on interrogatory requests for production that were never answered. Now, if you're inclined to rule on the motions for summary judgment, it's really kind of a non-issue. So I'll put that secondary.
Let me ask
motion,
really quickly,
yeah.
let me ask really quickly, Mr. Quinones, just because I know we've had everybody's has a lot of moving parts. Was there a response on the motion to compel?
No, Judge, we don't.
Okay,
We're there yet, Judge.
thank you. Okay, Mr. Body, go ahead. I don't know if you were finished.
Yes, Judge. And so, well, and so that goes to another point, Judge, as well on the discoveries, that I'm hesitant because they need to provide the discovery, yet I don't want to move the trial date now again, because they'd be kind of benefiting from their own, I would guess, say, misdeeds on not responding to discovery entirely. You know, wasting the time of my client, Mr. Brown's client. It does cost real time, attorney's fees. You know, after 2 years, I think enough has been enough on this. We went through and gave a very detailed motion for summary judgment. We went through all the deposition transcripts, attached them. We're very specific on the testimony that all the people gave. But the bottom line is this, Judge, and I don't want to kind of beat a dead horse here, is that he's alleged these causes of action. We've gone through our motions, pointed out what was deficient on the elements. He's unable to show that he has even a scintilla of evidence. And if he does happen to, I mean, there's no genuine issue of material fact on some of these things. He's admitted to certain things in this dispute that he has no evidence of the 3 allegations. And, you know, one of them I mentioned was a $7,000 job at W. Silver Recycling. Another one was an issue with a supply house where money was paid for some supplies. You know, really, Judge, this falls into, it's 2 business owners, and they didn't talk to each other, and there's mismanagement between both of them, negligence, or not talking to each other. Whether or not it actually falls into giving a cause of action to file a lawsuit against one another, it doesn't rise to that level. I mean, a lot of things also fall into the business judgment role. They weren't good businessmen together, and they needed to break apart. But yeah, 2 years into it, I just think there's no proof that my client has committed, any of those wrongs that he alleges that gives to rise to cause of action. There's no nexus that, defendant Nunez is the cause of any of those. And the last thing I'll bring up, Judge, and this is kind of a fundamental business issue too, is that when he alleges losses to the business, for example, he says, well, there was this building kit that was taken and I was damaged in the amount of $40,000. That's not actually accurate. That premise itself is wrong. If they own a business 50-50, then we own all the assets 50-50. If we lose something that's worth $40,000, we both lost $20,000 of value. So his damages, even if they were correct and his lawsuit was correct on those causes of action, he's only owed half of what he actually alleges because he didn't own the whole company. And so, that's just, again, another issue as to damages, that he does not have any evidence to support. So I know I beat this long enough, so that's all I have, Your Honor.
Mr. Quinones?
I guess first the response to this case taking a long time because it's my fault. It's not true. If the court looks at the docket, there's been several delays for various reasons, but it's not to prolong this case. My client is paying the same expenses. There's no insurance on my client's part either. But to get to the substance of the case, what essentially is happening, Judge, is this is more than just a company disagreement. This is more than just a bad business investment. This is stealing from the company. That's a breach of fiduciary duty to the company, to my client. That's clear that there's some movement by Mr. Nunez to hide company assets. One of the assets is the building that was on the trailer. It's gone, Judge. And Mr. Nunez, in his deposition and the ties that his brother had to D. Optimus, show that that he knows, even though he's denying where the building is, he either knows where the building is, or he's hiding it, or he sold it to D. Optimus for profit that was not incorporated into the company assets. That's what the lawsuit's about, Judge. If the jury doesn't believe it, then it doesn't believe it. But we need the case to be sent to the jury. Now, the assuming, Judge, that the worker or the secretary allowed D. Optimus to enter the facilities. This was not out in the open. This trailer was at company property. Assuming that the worker allowed them to enter the building and to enter the facility and to enter the premises, that doesn't allow them to take company property, whether it's by a Justin Merida or somebody else. They represented to Dancel that it was D. Optimus the entire time. There's nobody else on her affidavit. So assuming that they had permission to be on that premise, there's no permission to take company assets away. So to grant summary judgment against D. Optimus because it was somebody else that took it, that's not an excuse. They were there on the property. It's clear from the affidavit that they took the property. They didn't have permission to take a building, a $40,000 building. And so that's our dispute. That's our complaint. That's what our entire complaint is about against D. Optimus. Now, with regards to Mr. Nunez, on page 11 of the summary judgment, Judge, they're saying that it's deemed admissions, that my client has deemed admissions. On page 11 of their summary judgments, they're admitting that the responses were received. Mr. Contreras' responses were due October 18, 2023. No responses were received until October 15th. So they're admitting that they were received before the deadline on page 11. So that's why I didn't respond to that. There's no deemed admissions, according to their. Now, with regard to the breach of of contract. This is more of a breach of fiduciary duty. If the court wants to dismiss the breach of contract, we have no objection to that. There is a clear breach of fiduciary duty. With regards to the other issues, there was a $7,000 check that was written to a construction, I'm sorry, a building construction supplier for $7,000. That was written by Carlos Nunez. That money was used to purchase materials without a purchase order. There's no purchase order. And the person that did not distribute the purchase order is the one that's been avoiding 2 depositions. That company, Carlos Nunez used to work for. And so we want to know where this material is or where the $7,000 went to, and why material was purchased for $7,000 without my client knowing about it. That's the second claim that we have. The third claim is on the third claim is on W Silver. We have a deposition which we included from an engineer at W Silver. Mr. Nunez was denying that there was any work received, any money received from W Silver, which my client has also testified that he knew nothing about this W Silver account. That's because Mr. Nunez was working for W Silver, and the engineer confirmed that through his deposition. Mr. Nunez was ciphering work at W Silver and depositing that money outside of the company assets. That's why we sued on behalf of, that's why my client sued to get the assets returned from W Silver for all the work. For it was the construction of a paint operator, a massive construction for a paint operator that was not deposited in the company account. All of that work, all of that material, all of those funds were siphoned by Mr. Nunez. And we had the deposition, we attached the deposition from an engineer at W Silver. So as you can see, Judge, there's been seven depositions. We have spent a lot of time on this case. It's not to my client, it's not because my client is delaying any of this. It's simply to get to the heart of the matter. But when you have people denying any sort of wrongdoing, when you have people denying that they've done anything wrong, the evidence has clearly shown that it's enough fact issues to bring to the jury in this case to deny the request for motion for summary judgments. Thank you, Judge.
I also have Mr. Body, did you have a reply?
Just one thing I want to mention, Judge, on the admissions, is that there was a typo actually in the MSJ that we said they were received on the 15th. It was actually October 25th. And the exhibit number 6, which is attached, which are Mr. Quinones's actual response on behalf of his client, shows a certificate of service of the 25th. So we sent discovery on September 18th. It was due October 18th. He sent his answers, his responses to request for admissions 7 days late on the 25th. And I think he'd probably stipulate that that's what his actual response date was. But that's the only, yeah.
Okay. And so anything else on the summary judgment, Mr. Body?
Judge, I would just rely on our pleadings. The motions filed and responses, you know, we're making argument here at this hearing, but you know, everything that Mr. Quinones is saying on behalf of his client, you know, he doesn't address a lot of those things in his responses. And so what he says is not evidence, and they're stuck with the lawsuit they filed, the petition they filed, and the response that he filed, and the evidence has been able to come up with. And so I think, you know, summary judgment should be granted for my client on those causes of action.
Mr. Quinones, we also had the motion to compel set for today. Did you have a response to that?
No, Your Honor, didn't have it set for today. I'm sorry, Judge, let me look.
I think I was thinking as you all are speaking that it included the admissions, but it's not. It's interrogatories and back to us.
I'm sorry, Judge, if we could get a different date for that, I'll be happy to respond. I didn't know it was separate today. I saw the motions for summary judgments and the final pretrial conference, but that's all I saw, Judge. I apologize for that. I'll respond.
Well, we have a short window to take care of things. So if you're gonna have a written response, I need to see something by noon tomorrow.
That'll be fine, Judge. Do that.
Okay. I think that takes care of everything that was said today, if I'm not mistaken. I don't think we need to go over any kind of final civil pretrial. I guess one other question, I haven't heard this, so maybe I'm asking a dumb question. There isn't any further mediation set, is there?
No, Your Honor.
Okay, all right. Okay, so on the motion to compel, I'll go ahead and await Mr. Quiñones's response to that. I did not have Mr. Quiñones your motion for leave or your motion to order the appearance at deposition. I'm comfortable taking those on your pleading so that we can get everything wrapped up by next Wednesday. That's my deadline to have rulings on all of these. Does anybody have an issue with that?
No, Your Honor.
Not hearing anything. I'll have that as my deadline. Mr. Quiñones, please email anything that you file on that motion to compel to Ms. Hernandez so I can review it, okay?
Yes, Your Honor.
Gentlemen, thank you for your time.
Thank you.
All right, Mr. Marufa, can we take care of some that are not going to take as long? I know we have a friendly suit, so if there's any that we can get out quickly.
I also have the second one on page 1, Judge. In cause number 2022 DCV 2483, Matthew Thomas Bell versus Brian Misael Arellano et al. Announcement of counsel, please.
Good morning, Your Honor. Manny Morgan on behalf of Mr. Bell.
Good morning.
Roy Brown on behalf of Mr. Ariano.
Final civil pretrial, gentlemen, where are we on this one?
Your Honor, we're presently set for mediation January 4th. So we're hopeful that we can settle it. However, I do want to mention to the court that our office is set for trial on the same day in a separate case in the 243rd. And I believe, hopefully we can settle it, but we might have to have one of the two trials moved.
Okay, so I have you down for docket call. I'm sure I'll hear from you either way before that date. Alrighty?
Understood, Your Honor. Thank you.
Thank you for your time.
Thank you.
Who's next?
Top of page 6, Judge. In cause number 2023 DCV 1858.
Hold on a second. I mean, are there not other cases that, this is the friendly suit, so it's gonna take a minute, right? We have witnesses, or is it not going?
Yes, it's going to have Mr. Barrera here.
Okay, so between, there's a default 0877. There's a motion for continuance 2141. Are the parties here for that?
Yes, Judge.
I think the motion for continuance, I don't know if it's gonna take a long time.
Okay, Judge, page 3.
Yes, Your Honor. I'm also here present along with Mr. Rincon.
In cause number 2022 DCV 2141, Hector Medrano et al. Versus Marian Shields et al. Announcement of counsel, please.
Greg Suquet for plaintiff Hector Medrano and Rocio de la Fuente.
Carlos Rincon and Amado Montoya for the defendants, Shields and Cook Trucking.
Good morning. I have this down for both final civil pretrial, but there was a motion for continuance. Is that an agreed motion?
Yes, Your Honor. We filed it initially, it was opposed. I spoke to plaintiff's counsel and it's now unopposed, provided that we work to get fairly soon reset. Our case is just not jury trial ready. It's close. We are at a point of having to complete expert depositions that are set. They just haven't been completed. And we have an agreed mediator with Judge Villa, but he wasn't available before the trial date. And so my clients needed these expert depositions to take a full consideration of the case. And so if Your Honor has, and plus we have out-of-town witnesses, everybody, there's a lot of them and parties. So if Your Honor had a trial date in late April, early May, we think that'd be plenty of time.
Myrna, where are we on trial dates in May? Is there anything available at the beginning of May? And I'm assuming everybody's on board with that. Is that right?
The sooner the better, Judge, but yes, Mr. Rincon is correct.
I'm thinking that's going to be probably the best we can do, just knowing that our first half of the year, I'm really, if we're talking about regularly scheduled stuff, we're looking at summer or later. So this would be already kind of full.
Judge, May 3rd is available.
Okay. That's
Yes,
good.
Your Honor. May 3rd. And Mr. Montoya, who has my trial calendar, you can assure me with your life that we're available May 3rd?
No, Your Honor, we are not available May 3rd.
I am available?
We are not, no, Your Honor.
Do you have anything in late April, Judge?
Let's see. Yeah, the sooner we get, I think the more difficult it is, but I know we've been specially setting things already.
April 19th and 26th.
Both work for us, Your Honor.
Mr. Sokat?
April 19th and April 26th. Did I hear that correctly, Judge?
Yes.
Yes, sir.
Yes, that works for us, Judge.
Okay, do you all need a scheduling order for that kind of timetable? No?
We could, Your Honor, but truthfully, the case is basically worked up.
Okay.
So we just need it mediated.
All right. If anything comes up, then just let us know. I'm sure you all
Okay.
either agree. We'll use that date with your docket call on the Wednesday before. That will have a final civil pretrial deadline 30 days before that, and that'll be your mediation deadline. So I'm sure that'll give you a window. We will be canceling the January 17th and January 9th setting. Okay?
All right, Judge.
Time.
Are we excused?
You are. Have a good day. Thank you.
Thank you, Judge.
Okay. Is there another on the default possibly? Are they here?
I have the middle of page 5, Judge.
No, my question is 2023 DCV 0877, is anyone here on that case?
No, Judge, nobody's here on that case.
Call it, please.
In cause number 2023 DCV 0877, Galaxy International Purchasing LLC versus Francisca Serna. Announcement of counsel, please.
Is there anyone in the waiting room on this case, Mr. Marufo?
No, Judge.
Have anyone on court staff received any communication from either of the parties?
I have
No,
not.
ma'am.
This is the second setting where the parties have failed to appear, so the case will be dismissed for want of prosecution. Please get me the order. Thank you. Who's next?
Middle of page 5, Judge.
Okay.
In cause number 2022 DCV 3787, Ankur Patel versus Padilla Holmes et al. Announcement of counsel, please.
Your Honor, Blake Downey on behalf of plaintiffs.
Morning.
Morning, Your Honor. David Mirasa on behalf of the defendants.
Gentlemen, we're here on a status conference. Is this one where we've been kind of status conferencing it? Let me look in. How are we on this one?
Your Honor, this case is subject to binding arbitration. All the parties agree to that. Mr. Acosta, who was working with Mr. Mirazo, was on that case. Mr. Mirazo and I have not talked about the arbitrator. We were leaning towards Walker Croson arbitrating the case. Unfortunately, I've now become adverse to Mr. Croson on a case, so I don't think he can be our arbitrator. So I just need to get with Mr. Mirazo and see if we can figure out who will serve.
And that's why we keep coming back. Okay, so I'm going to reset you for 60 days. Good luck. Thank you.
Thank you.
Mr. Mirazo, is that okay?
Oh, yes, Your Honor. Absolutely.
Okay.
Thank you.
All righty. Thank you very much.
Thank you, Your Honor.
Who's next?
The one right below it, Judge, in cause number 2022 DCV 2118, Maria Cristina Cerrato versus the Toro Company. Announcement of counsel, please.
Kayla Miller on behalf of the defendant.
Is there anyone here on behalf of plaintiff? Have we received any communication from Ms. Cerrato?
I have not, Judge.
We have not either.
I think this was reset to double check, so for failure to prosecute, case is dismissed. Thank you, Ms. Miller, for your patience.
Thank you. Have a good day.
You too. Who's next?
Staying on the bottom of page 5, Judge.
Mhm.
In cause number 2021 DCV 1635, Gerardo G. Garcia et al. Versus Fernie R. Acevedes. Announcement of counsel, please.
Good morning, Your Honor. James Fuel on behalf of the plaintiff.
Good morning, Your Honor. Lisa Hayes for the defendant.
And we are set for a final civil pretrial, and we're set for jury trial in February. How are we doing?
From the plaintiff's perspective, Your Honor, we mediated the case unsuccessfully recently, and we'd like to proceed to trial.
Ms. Hayes?
Your Honor, we'll be asking for continuance. The discovery in this case has not come close to being completed. Not a single deposition has been taken over the course of the last couple of years. I have been cooperative in the plaintiff's 2 requests for continuance. So I will be filing a motion, and I would hope they would not oppose it, given the courtesy that's been shown to the plaintiff.
It looks like we did have, I don't know, I hate to call it a reboot. I just see that we have that discovery control, the scheduling order in April of 2023. There was a previous motion for continuance. So Ms. Hayes, if you'll just, the sooner you can get a motion to the court, the better, so we can know if we're gonna be pushing you guys down the road or not, okay? If
Yes, ma'am.
anything comes up in the interim, please, that requires a hearing, let us know. With the holidays, scheduling is gonna be a little tricky.
Your Honor, if a continuance is going to be granted, can we get a trial setting relatively soon?
Well,
This is a 2-year-old case.
Are you agreeing to the continuance, or?
It's 2 years old. The defendants have not served any discovery, but I do understand Mrs. Hayes' position, and if it was a quick trial setting, then that would help me determine whether I'm going to oppose or not.
My thought would be we're probably looking at August, September. I'm not inclined to put it just on what I'm kind of hearing right now as soon as April. No, you would probably get a 9-month window.
Okay.
Okay. So let me know, and if we need to get it reset, I mean, if you all are in agreement, I'll just go based on the motion. If not, we can hear something before the trial setting. Okay.
Yes, ma'am.
Thank you.
Thank you for
Thank you,
your
Your
time.
Honor.
Have a good day.
You too.
What's next?
Top of page 5, Judge.
Mm-hmm.
In cause number 2022 DCV 3622, Mary Gonzalez versus Jovencio Pacheco et al. Announcement of counsel, please.
Good morning, Your Honor. Nassim Saloom on behalf of the plaintiff.
Enrique Lopez on behalf of the defendants, Your Honor.
Okay, we're scheduled for a motion to withdraw. Mr. Saloom, that's yours, and the status conference. Is your client here by any chance?
No, Your Honor, unfortunately not.
Okay.
I have Mr. Jovencio for.
Those are my clients, Your Honor.
Okay. So, Mr. Saloom, what's going on?
Thank you, Judge. May it please the court.
Yes,
Fairly brief, Your Honor. Unfortunately, my client has failed to maintain both effective communications and her financial obligations to our office. Most recently, we had a scheduled mediation for the 20th. The day of the mediation, I was unable to get in contact with her, and I received a phone call from her daughter stating that she was hospitalized and due to a recent medical emergency. Since that time, I've not been able to communicate with her. I have her email, her cell phone, etc. And I've basically left no choice but to withdraw from representation at this time, Your Honor. I did provide a copy of my motion to. to my client as well as the defendants. At this time, Your Honor, unfortunately, I'm seeking an order granting my withdrawal.
So you sent this to Ms. Gonzalez when?
The day it was filed, Your Honor, on this December 1st, Your Honor.
Okay. And let me see, your certificate of conference, undersigned, the defendant's attorney, okay.
Right.
I want to know if Ms. Gonzalez knows of your motion and if she knew of today's hearing.
Yes, Your Honor. Again, I did email her this motion. I believe I emailed her the court sitting, I believe, Your Honor. But again, I haven't heard a response. I don't know.
Okay,
What's
so
the status?
I want to see if we can have a more certain contact with Ms. Gonzalez. I'm not having so much of an issue with you withdrawing, Mr. Saloom, but I saw in your motion, you have an address. If you have an email for her, I need you to send that to the court along with all of her contact information so the court can send her notice of a hearing on your motion to withdraw.
Yes, ma'am.
That will be in January 10th at 11 a.m. I see the trial track. I'm sure this is frustrating for you, Mr. Lopez, and your clients, but I want to make sure if we have better information on her or her status or what we're going to do, I don't know if we can salvage that trial date or what we'll do. But without having confirmation that she had notice of the motion and the hearing, when we send out that notice, well, I guess we can track the email, but we'll need to get some kind of tracking on the notice for the hearing. So we'll see if that shakes things up a little bit to see if she shows up. Had we received any communications from Ms. Gonzalez?
No, ma'am.
Okay. All right, Mr. Saloom, please provide that to my court staff and we will reset this for the January date.
Your Honor, but I have
Yes, sir.
another matter to address to the court.
Yes, sir.
I requested this status hearing, actually, Your Honor. We, like Mr. Saloom indicated, we were scheduled for mediation on November the 20th, and the day of the mediation, I received an email that there was a medical emergency and it had to be canceled, and I understand that. The problem is that we have a motion pending before Your Honor, and that's defendant's motion to compel plaintiff to deposit the rent monies into the registry of the court. We had a hearing on that, but because the mediation was within 30 days, the court deferred any rulings and requested that I amended my motion to include the most recent non-payment of rents. And right now, the total, not including this month, is $33,750. Essentially, Mary Gonzalez, the plaintiff, has not paid the rent for close to 2 years now. And this is very troublesome, that there's delays and delays. And the last one was the mediation. And I think the court was kind of waiting to see if the parties could resolve this matter at mediation. Then the court probably did not have to rule. And I agree with that. And that made perfect sense. But now I'm hearing the mediation is canceled. Mr. Saloom is withdrawing from the case, and the plaintiff has not paid the rent, and now we're at a total of $33,750 behind, almost 2 years of rent free. So I'm asking the court to look at make a ruling on my motion to compel the plaintiff to deposit the money into the registry of the court, as had previously been addressed.
Okay, and your motion says $32,250. You're telling me to date now, this was filed November 13th. We're a month later, it's $33,750. Is that right?
Yes, Your Honor.
Okay. Okay, but you all didn't go to mediation, so there's been nothing discussed. But we
Mm.
did have the full hearing on it. You all, okay. All right. Mr. Saloom, do you have anything for the court? I know it's,
Your Honor, I made my client aware of the court's order regarding rent payments. I don't believe at the time she had a lump sum amount. It was, I forgot the figure, but it was a substantial amount. Without breaching my attorney-client, duties, I informed her that this amount needed to be paid, but there's just unfortunately been a complete collapse of communications, effective communications. So I'm kind of stuck in the middle.
okay. And in that case, Mr. Lopez, go ahead and send me a proposed order. What I'm going to do is I'm going to go back. What was the hearing? It was on November 1st. Is that right?
Yes, Your Honor, but this case, Your Honor, you had already granted a motion. And at that point, that was back in July 26th, you had ordered the plaintiff to make the $19,500 deposit into the registry of the court, and further order that she continue paying the $1,500 a month beginning June 15. So there's already an order by the court to do that. This is a compel motion.
Well, that's what I'm asking you to give me an order on your motion to compel. Okay.
Yes, Your Honor.
I mean, there's an amended motion as of November 13th. I don't know if you want to amend it again to update the amounts, because that's not the amount that you're asking for today. And I will review it and rule on your motion, your amended motion to compel.
Your Honor, I'm sorry. Well, may I have an opportunity to respond to the amended motion, Your Honor?
It's not set today, but go ahead.
Oh, I mean, I didn't mean right now, Your Honor. Just with the updated figures and the request of the defendants, I would like an opportunity to respond.
Well, it's been filed for a month. So
if the court would permit.
Well, the court is very frustrated because now understanding that Ms. Gonzalez, I don't know, is MIA, you all haven't been diligent about meeting any deadlines in this case. So I hear urgency and then no movement or no action on your part.
Your Honor.
Mr. Saloom, if you have a response, file it by the end of the day. Mr. Lopez, get me your order.
Yes,
thank you, Your Honor.
Thank you very much.
Thank you, Your Honor.
Thank you.
Who's next?
Top of page 6, Judge. In cause number 2023 DCV 1858, Lourdes Veronica Avilar et al. Versus Luis Manuel Alviar.
Alviar.
Thank you, Judge. Announcement of counsel, please.
James Kennedy for the plaintiff, Your Honor.
Frank Barrera for the defendant, Your Honor.
Diana Valdez for the minor, Your Honor.
Good morning. We were scheduled an hour ago for a friendly suit. So thank you for your patience, Ms. Valdez. I did receive your report as well. So thank you for sending that ahead of time. I do see there's Ms. Alviar appearing as well. We are scheduled for a friendly suit. Mr. Kennedy?
Yes, Your Honor. I saw Ms. Alviar there earlier, so just maybe if she could log on the video.
There we go. Okay.
And take her mute button off.
Ms. Alviar, we're gonna be asking you some questions. So if you would please unmute, and then I do need to swear you in.
Okay.
Oh, perfect. Yay. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Thank you very much. You can put your hand down, Mr. Kennedy. You may proceed.
Thank you, Your Honor. Could you please state your name?
Lourdes Alviar.
And are you the mother of Isabel Alviar?
Yes.
And Isabel is, I guess her date of birth was in September 16th, 2014?
Yes, sir.
And how old is she today?
She is 9 years old.
Okay. You understand you're here today concerning an accident she was involved in on July the 24th, 2021?
Yes.
And in that particular case, the defendant tendered the policy limit maximum of $30,000. You understand that, right?
Yes, sir.
Your daughter received treatment at by ambulance to El Paso Fire Department, University Medical Center, Texas Tech, El Paso Children's Hospital, and those bills were paid by Medicaid, correct?
Yes, sir.
What injuries did your daughter sustain as a result of this accident?
She had to get surgery, a laparoscopy done on her GI. Her intestine detached from her colon, so they had to do an emergency surgery to attach it again.
And we're also sorry
It
that
was a rupture.
we're so sorry she went through that, okay? So,
Thank you.
you understand, unfortunately, sometimes there's only so much insurance involved in cases, right?
Yes.
And in this particular matter, all the insurance that was available for your daughter to recover was $30,000. You understand
Yes,
that,
sir.
right?
Yes, sir.
And prior to today, you had a chance to meet with the guardian ad litem in this case, Miss Diana Valdez, correct?
Yes.
And you had a chance, since your daughter is younger, to look at investment options, and that's detailed in the report by Miss Valdez about how to plan for your daughter's future with the money left over to help her go to college and have some type of recovery from this. You understand that,
Yes. Yes, sir.
right? In this particular case, there are attorney's fees of 40% or $12,000. You understand that, correct?
Yes, sir.
The expenses are $750. You understand that?
Yes.
The medical charges after they were reduced from Medicaid are $684.85. You understand that, right?
Yes, sir.
And that leaves your daughter with a net sum of $16,565.15 that she's not really actually going to receive now because it's going to go into some different type of investments to better her when she gets older. You understand that, right?
Yeah.
In this particular case, you could have taken this case to trial where your daughter could receive less than the 30,000, more than the 30,000, exactly 30,000, or nothing at all. Those are the risks that you weighed when making this decision about the settlement, correct?
Yes, sir.
Given the amount of insurance coverage involved and the fact that the insurance company was paying the maximum amount, you feel it's in your daughter's best interest for this court to approve the settlement.
Yes, sir.
You understand you may have to execute documents if the court does approve the settlement for the investment of those funds, for any release documents reflecting this breakdown that you and I just discussed. Basically anything that affirms what we're doing here today in terms of the settlement amounts and where it is to be paid or distributed. You understand you may have to cooperate for that, correct?
Yes.
And you agree to do that.
Yes, sir.
You feel this settlement proposal and the investment options that you chose with the assistance of Ms. Valdez, but it was solely your decision, are in the best interest of your daughter.
Yes, sir.
You're asking this court to approve the settlement.
Yes, sir.
You understand you can't bring a claim later on against the defendant in this case if this court approves the settlement, and your daughter cannot bring a claim again. It's a full and final settlement of which you can't go back later and allege anything else. It's a complete settlement against these defendants, and you can never ever do anything again, you or your daughter, right?
Yes.
Understanding all of that, you're still asking the court to approve the settlement.
Yes, sir.
Okay, I'll pass the witness, Your Honor.
Thank you. I'll go to Ms. Valdez and then we'll wrap up with you, Mr. Barrera.
Okay, very good. Good morning, Ms. Alviar.
Good morning.
Yes, ma'am. So you recall you and I had an opportunity to meet on multiple occasions, correct?
Yes, ma'am.
And we discussed different options to see how we could maximize the settlement amount for the benefit of your daughter, correct?
Yes.
We looked at possibly depositing those funds in the registry of the court. Do you remember that?
Yes.
We also explored potentially investing these funds in a CD with a local credit union.
Yes.
And finally, we looked at the possibility of an annuity to see which option would maximize the recovery for your daughter, correct?
Yes, ma'am.
Okay. And you recall that with the annuity company, we looked at 3 different options.
Yes.
Okay. And ultimately, you decided on the second option, which would generate more than $10,000 in interest to benefit your daughter by the age of 22, correct?
Yes. Mhm.
Okay. So with respect to the option that we selected, you recall that we selected one with a college plan embedded in it, correct?
Ma'am.
And that would provide for 4 annual payments in the amount of $3,000 for your daughter beginning at the age of 18, correct?
Yes.
And then at the time that she would turn 22, she would receive a lump sum payment in the amount of $16,222, correct?
Yes, ma'am.
And so ultimately, your daughter's going to take the total of $28,222 by going with this option of this particular annuity, correct?
Yes, ma'am.
Okay. And you decided that it would be best for your daughter not to take all that money at the time that she turned 18, correct?
Yes.
Yeah. And you wanted to ensure that she was mature and had been through a little bit of school before she obtained the rest of those perks.
Of course.
Okay, very good. And you believe that the options that we examined are in the best interest of your daughter.
Yes, I do.
Very good. And we also discussed how your daughter has recovered since the accident, correct?
Yes, ma'am.
And I had an opportunity to meet with her and to talk to her and ask her a little bit about school and other activities, correct?
Yes.
Yes, very good. Your Honor, I have no further questions. I do want to add that we wanted to have Isabella here today, but she had an examination at school. And unfortunately, because of the timing and with the end of the semester approaching, she was unable to attend. But, you know, typically I like to have the minor present so that Your Honor can meet her. I will tell you, Judge, that I did have an opportunity to visit with her. Very sweet little girl. Appears to be doing very well. Mom did tell me, you know, that on occasion she still has an issue here and there with respect to the intestinal injury that she sustained. But for the most part, she's recovered well. She's a very mild-natured and good girl. And so with that, Your Honor, I pass the witness.
Thank you, Ms. Valdez. Thank you very much. Mr. Barrera?
Thank you, Judge. Good morning, Ms. Alviar. My name is Frank Barrera, and I represent the defendant Luis Manuel Alviar in this matter. Do you understand who I am and who I represent?
Yes.
Okay. I think pretty much almost everything has been covered, so I really just have 2 questions just to make sure we're on the same page. Do you understand that $30,000 is all that the defendant or his insurance company is going to pay to settle this case?
Yes, I do.
And do you understand that that $30,000 will be paid in the amounts that Mr. Kennedy went over when he was asking his questions?
Yes.
And you're asking the court today to approve the settlement in accordance with those terms, correct?
Yes, sir.
Okay. Thank you very much. I pass the witness.
Okay, anything else? No?
Nothing further from the plaintiff, Your Honor.
Thank you very much, Ms. Alviar. Thank you very much again for your patience this morning, but for also, it is very clear to the court that you've been very thoughtful about how to proceed here. And so I wish not only you and your daughter well, but I will find that this settlement is in the best interest of your daughter. And I am going to approve the settlement. So thank you. It goes a long way to kind of see that kind of thoughtfulness to assure the court that this is the best way forward. I hope you all have a smooth road ahead and happy holidays. Counsel, thank you, ma'am. Mr. Barrera?
Yeah, Judge, I just wanted to bring to your attention that I think that this matter actually has 2 different cause numbers, and that's because when we received it, we were not aware that there was already a lawsuit on file, so we filed another lawsuit for the friendly suit, which is this cause number. There's another cause number for this matter, so I just wanted to bring that to your attention. The other cause number is 2022 DCV 3557.
With respect to the friendly suit, as I was mentioning, that is going to be approved. Honestly, I've gotten so many emails. I don't know if you already have proposed documents to the court. If you do, if you haven't sent them over, I know I'll be expecting them soon. And I will review them and have them filed with the papers of the court, okay?
Yes, Judge.
Thank you very much. Ms. Alviar, have a good day. Thank you.
You too, thank you.
Thank you,
Thank you, Your Honor.
Is that the last one?
Yes, Judge.